So earlier this year, Utah filed a lawsuit with the United States Supreme Court asking the U.S. Supreme Court to consider if Congress's 1952 Land Management Act was unconstitutional. The Land Management Act is what set up the Bureau of Land Management to manage unappropriated properties in the western United States. This is a particularly interesting case, not just for Utah, but for the entire West, including Idaho. Here in Idaho, 72% of our state's land is public, the vast majority of this being held by the federal government. Some of it is tribal, some of it is national parks, but a good chunk of it, about 30% of the state of Idaho, is what we call unappropriated federal land. It's federal land that's just sitting there. It's managed by the Bureau of Land Management. It doesn't have a designated purpose. It's not a national park. It's not a military installation. It's not tribal. It's just unappropriated. And this was set up under that 1952 Act that created the Bureau of Land Management that Utah is asking the Supreme Court to decide if it is constitutional. The problem is Utah and all, at least 12 states in the western United States have a problem. And it's not the 1952 Land Management Act. It's a lot deeper than that. So the very first thing that Congress is going to claim when Utah gets to the Supreme Court and says, you guys own way too much federal land, it's something like 90% in Nevada. It's 70+% here in Idaho. When they get to the Supreme Court, if the court even agrees to hear this case, Congress is going to argue, the federal government is going to argue that they absolutely have the right to hold this land because of Article 4, Section 3, Clause 2 of the U.S. Constitution. This is known as the Property Clause. And the Property Clause says, and I quote, "The Congress shall have power to dispose of and make all needful rules and regulations respecting territory or other property belonging to the United States." So there's two things there. There's territory and there's property. And Congress has absolute power to dispose of that and to make all needful rules and regulations. And so Congress would say, look, the Constitution gives us absolute power to dispose of and to regulate and to make rules. Indeed, the Supreme Court has in the past gone so far as to assert that if Congress wanted to build a fence around all the federal land in the western United States and deny the citizens entry, that they would have that right under the Constitution. The Constitution doesn't explicitly say that, but that is the prevailing court interpretation at the time. So Congress is just going to say that. They're going to say, look, we have, under the Constitution, total rights over territory and property. But what Utah could argue, and probably should argue, is that there is a difference between U.S. property and U.S. territory and states, and the sovereignty that comes with being a state. And the place they should go to make that argument is the very next sentence in Article 4, Section 3. So Congress has absolute power to dispose of and make needful rules and regulations respecting territory or other property. And then this section continues, and nothing in this Constitution shall be construed as to prejudice the claims of the United States or of any particular state. And this is very important because after just vesting the Congress with the authority to manage and dispose and regulate and rule territory, not Congress, but the founders go on to explicitly state this does not take away from or dispel the claims of any particular state. So here's the question. Is there a difference? Because you could argue the founders are making a differentiation between territories and states. They include them in opposites. It's almost like if a state can't have a claim to territory, then what are they arguing over, right? So Congress has authority to dispel the territory, but states can make a claim to it. But here's the question. Can these states, like Utah, do they have standing to make this claim? The answer is probably not, and it's their own fault, Idaho included. So the reason is when 12 of the 50 states were admitted to the Union, Most of the states admitted after the Civil War were required as a condition from Congress to renounce any claim to public land. Little bit of a history lesson. 1846, the United States acquires from Britain the territory from the Rocky Mountains to the Pacific Ocean. It's called the Oregon Treaty in 1846. Congress has this authority under the U.S. Constitution to ratify treaties, and now they have this territory. So from 1846 to 1890, Idaho was purely territory and was governed under the constitutional authority for Congress to make all the rules, and they did. In 1888, a senator from the state of Oregon proposed what's called the Enabling Act. The Enabling Act was the legislation that would make Idaho a state. And it created three types of property that they were going to give this, that Congress was going to give the state of Idaho. The first kind of property was about 2 million acres of territorial land, federal territorial land, that would be given to the state of Idaho for the public school system. And with that, Congress said if Idaho ever sells that land, they have to use all of that money and the interest from it to fund the public schools. So condition one, tied to 2 million acres of land that we were given, was that we have to maintain a public school system. The second condition has to do with the land-grant University of Idaho. All the land that was owned by the federal government there was given to the state of Idaho under the condition that if Idaho ever sold that land, they must sell it for a minimum of $10 per acre, and all that money and the interest accrued thereon has to be used to finance the land-grant university system. So there were two kinds of land that were given to Idaho that had strings attached, the university and the public school land. This is in the Enabling Act in Idaho. But what is probably the most disturbing is the following statement in Idaho's Enabling Act that says, and I quote, "The state of Idaho shall not be entitled to any further or other grants of land for any purpose than as expressly provided in this act." The case that we're dealing with that's getting escalated to the U.S. Supreme Court about the 1952 Land Management Act is not the problem. The problem is Idaho's admission to the Union was done on the terms that we didn't get any of the federal land. And the land that we did get, most of it, was tied to the public schools and the land-grant university and has strings attached for how we can behave with it. The 70% of the state of Idaho that is controlled by the federal government, that land remains in the control of the federal government as a condition of our statehood. In order for Utah or Idaho to prevail on this regard, we would have to challenge the constitutionality of the Statehood Enabling Act itself. We would have to say, yes, we're a valid state, but no, the federal government saying we can't ever get control of that land, that's unconstitutional and it exceeds the bounds of the Constitution. The problem is, Idaho, like 12 other Western states, disclaimed our title or claim to any of that federal land in our Constitution. And we did so, it was a little bit of a carrot and stick situation. We wanted to be a state. Congress said, we'll make you a state, but you have to agree to our terms, which means you don't get any of the federal land, which is most of it. So Idaho put that in our Constitution. And I'll read you the provisions of the Idaho Constitution disavowing this public land. This is in Article 21, Section 19 of the Idaho State Constitution. It says, "And the people of the state of Idaho do agree and declare that we forever disclaim all right and title to the unappropriated public lands lying within the boundaries thereof. And the same shall be subject to the disposition of the United States." And then we go on to say that we won't tax that land. We say no taxes shall be imposed by the state on the lands or property belonging to, or which may be hereafter purchased by, the United States or reserved for its use. And then we add a third provision. This is the irrevocability clause. we say this ordinance shall be irrevocable without the consent of the United States and the people of the state of Idaho. That provision, disclaiming all land that's owned by the federal government at territory to statehood time period, is found in 12 state constitutions. Idaho, Wyoming, Utah, Oklahoma, New Mexico, Arizona, Alaska, although Alaska does not use the word land, they use the word property, which more closely resembles the constitutional word, Washington, South Dakota, North Dakota, and Nevada. 2 states, Nevada and North Dakota, have since amended their constitution to change the provisions of those disclaimers. But here's the problem. If Idaho tries to go to federal court and say, we have a right to this land, we're going to have to argue that the act which admitted us as a state to the Union contains unconstitutional provisions. And in order to make a claim, we're going to have to repeal the provision in our state constitution which disclaims such claim. So the problem with Utah's court case trying to get the federal land doesn't have anything to do with Congress's action. It has to do with Idaho, Utah, and a bunch of other Western states' state constitutions that renounce those claims to federal land to begin with. We need to fix the state constitutions before we can ever have the standing to challenge the federal law. So, to sum up, Constitution gives Congress the authority to regulate territorial land. Congress creates Idaho as a state in 1890 and says, you don't get any of the land. And Idaho says in our Constitution, all right, we agree and we renounce all claim to the land. Now there's a movement that says, hey, we want that land. Well, you're going to have to, number one, remove the disclaimer from the state constitution, and 2, challenge the very law that made you a state in order to have any standing to ever obtain sovereignty of that land, or just get Congress to renounce the title. Both of those things are very steep hills to climb, but it will be interesting to see how things turn out in the coming days. Anyway, thanks for listening, and I will keep you updated on Utah's court case and the upcoming Idaho legislative session.